this short video, we'll be discussing a new law that affects many small businesses that have LLC or corporation structures, and a few others as well. The Corporate Transparency Act is a significant piece of legislation in the United States that is aimed at increasing transparency and combating financial crimes. It was enacted as part of the National Defense Authorization Act for fiscal year 2021 and became law on January 1st of that year. The regulations implemented under the law go into effect now, January 1st, 2024. The CTA introduces new reporting requirements related to beneficial ownership information, BOI, of certain legal entities. The objectives of the Corporate Transparency Act are enhancing transparency. The primary objective, of course, is to require certain entities to disclose information about their beneficial owners, making it more difficult for individuals or entities to hide their ownership interests in businesses. Also, combating money laundering. One of the key goals of the CTA is to combat this and other illicit financial activities. The CTA also aims to prevent the financing of terrorism by providing law enforcement and intelligence agencies with more comprehensive information about the individuals that are behind certain legal entities. The act is designed to strengthen national security by closing loopholes that could be exploited by malicious actors, and it also seeks to protect the integrity of the U.S. financial system by reducing the risk of money laundering, fraud, and other financial crimes, because it encourages responsible corporate behavior and ensures that businesses are held accountable for their ownership structures. The Act also aligns with international efforts to combat financial crimes, promotes cooperation and information sharing with foreign governments and agencies, and contributes to a more global approach to addressing these big problems of money laundering and terrorism financing. The CTA establishes an agency, the Financial Crimes Enforcement Network, known as FINCEN. FINCEN is a bureau of the United States Department of the Treasury, and its primary mission is to combat and prevent these financial crimes, money laundering, terrorist financing, as well as other illicit financial activities. FinCEN does this by collecting financial data from various sources, including banks, financial institutions, and other entities subject to the reporting requirements. This data includes suspicious activity reports, currency transaction reports, and reports related to foreign bank and financial accounts. FinCEN also analyzes and investigates the collected data to identify patterns, trends, and anomalies that may indicate financial crimes or illicit activities. And it plays a crucial role in regulating and overseeing financial institutions, money service businesses, and other entities to ensure that they comply with anti-money laundering and know your customer regulations. FinCEN acts as a central hub for sharing financial intelligence with various government agencies, including the FBI, the Internal Revenue Service, and the Department of Justice. This collaboration helps law enforcement agencies to investigate and prosecute financial crimes effectively. It also collaborates with foreign counterparts and international organizations to combat cross-border financial crimes. It facilitates information sharing and supports efforts to disrupt illicit financial networks on a global scale. And FinCEN has the authority to issue regulations related to anti-money laundering and counterterrorism financing. Among the rules set out in the CTA and by FinCEN is a requirement that certain so-called reporting entities must report information about all of their beneficial owners. So let's start with what companies have to comply. Under the CTA, reporting entities typically include the following. Most corporations, this includes both C corporations and S corporations, and most LLCs are considered reporting entities, although there are certain exemptions that apply based on the structure and ownership of the company. Certain partnerships, including general and limited partnerships, might be considered reporting entities if they meet certain criteria that I'll mention in a second. And other legal entities, the CTA may also apply to entities that are similar to corporations, LLCs, and limited partnerships based on specific criteria defined in legislation. Basically, it applies to any business entity or structure that's established by filing organizing documents with a government body, like a Secretary of State. If you're not sure whether this includes your business, be sure to check in with your attorney, because if you are covered, you have this obligation to report beneficial ownership information to FinCEN. So who is a beneficial owner? Well, beneficial owners are individuals that meet one or more of the following criteria. An individual who directly or indirectly owns 25% or more of the ownership interest in the reporting entity is considered a beneficial owner, or an individual who exercises substantial managerial control or responsibility over the reporting entity. And it should be noted that this can include individuals that have significant decision-making authority, CEOs, executives, officers, directors, or who have control over the entity's operations, even if they don't own any part of the company. And in addition to the above criteria, the CTA allows for the inclusion of other individuals who exercise substantial control over the management. This broader definition ensures that individuals who influence the entity's operations but might not meet the ownership percentage threshold are still covered. The breadth of this definition aims to prevent individuals and entities from concealing their ownership or control of other legal entities for illicit purposes, such as money laundering, terrorism financing, and other kinds of financial crimes. So, what is it that gets reported? Well, reporting entities are required to provide specific information about each of their beneficial owners. Specifically, the full legal name of the beneficial owner has to be reported. First, middle, and last names are required. The date of birth of each of these owners, as well as a current residential or business address. No P.O. boxes or mail drops. This requirement is for bona fide principal place of business or a where you sleep kind of domicile address. You're also required to provide a driver's license or passport number and an image of that document for record-keeping purposes, and social security numbers or tax ID numbers for the people who are considered beneficial owners. Covered entities have to report the percentage of ownership or control held by each beneficial owner to indicate the extent of their interest or influence in the company, and an explanation of the substantial control. Entities need to provide an explanation of how that substantial control is exercised by each beneficial owner. This helps to clarify the nature and extent of their involvement in the company's management. It's important that reporting entities provide accurate and complete information about their beneficial owners as required by the law. Failure to comply with these reporting requirements can result in legal and financial consequences. The CTA outlines the timeframes and situations when reports have to be submitted. Reporting entities that are newly formed or registered on or after January 1st, 2024 have to submit an initial report to the Financial Crimes Enforcement Network, FINCEN, within 30 days after formation. Entities that already exist on December 31st, 2023 have 1 year to submit their initial report. I recommend that this is done early and certainly not later than the anniversary date of your company's formation. Just make it a part of that annual renewal process. And changes in beneficial ownership have to be reported promptly after any of the changes take place, usually within 30 days of that change. So it's important that reporting entities adhere to these timeframes and requirements because failure to submit reports as required can result in legal and financial consequences, and that includes fines and penalties. The entities should maintain accurate records and report changes, within a quick time after they occur, within 30 days. So what are the consequences I've mentioned? Well, the CTA imposes penalties and sanctions on reporting entities that fail to meet their obligations. Here are some of the potential consequences for non-compliance. Civil penalties of as much as $500 per day or $10,000 per instance can occur. And in cases of willful or knowing noncompliance, individuals and entities might face criminal penalties, including fines and imprisonment. These charges can be brought against those who deliberately provide false or misleading information or knowingly violate the CTA. That applies to both the individuals and the company itself. Courts can issue injunctions or restraining orders against reporting entities that are not in compliance with CTA. These orders could restrict or prohibit certain activities or transactions until compliance is achieved. Non-compliant entities are at risk of losing certain of their legal protections, like limited liability. This could expose the owners and stakeholders to personal liability for the entity's actions and debts. And non-compliance could hinder or delay business transactions, including mergers, acquisitions, and financing. Potential partners, investors, or lenders might be reluctant to engage with entities that aren't in compliance. Noncompliance can also harm the company's reputation, which could impact relationships with customers, clients, partners, and other stakeholders. And of course, there are legal costs that can be incurred if you aren't in compliance, either defending against enforcement actions or addressing those compliance issues. So it's crucial that reporting entities take their obligations under the CTA seriously and ensure timely, accurate reporting of beneficial ownership information. It probably makes sense to seek legal counsel and make sure you understand exactly what's required so you can avoid these kind of severe consequences. FinCEN's reporting system and the required filing form are not yet available as of the recording of this video on December 20th, 2023. As of now, it looks like the reports are required to be submitted in PDF form through a secure online portal, and that will all go live on January 1st, 2024. Some third-party services have begun offering online tools that will make reporting easier. It's expected that FinCEN will adopt some kind of electronic submission at some time in the future, but for now, plan on that PDF format that you upload through a secure portal. Now, it's important to note that FinCEN has given some assurances that information you report to them will not be made available to the public. Access and use will be limited to government and law enforcement agencies and certain financial institutions. So that should put to bed some fears about identity theft being enabled by this and that kind of thing. So here are some proposed compliance strategies. Implement comprehensive record-keeping practices to maintain accurate, up-to-date records of beneficial ownership information. This includes keeping records on ownership percentages, control mechanisms, and any changes that might occur in beneficial ownership. Develop and document clear procedures for identifying and reporting beneficial owners as required by the CTA. Ensure that responsible individuals within the entity understand their roles and responsibilities in the reporting process. Having a checklist to follow and following it regularly is a very solid practice. Consider making this a part of your next annual meeting minutes or tax season process so it doesn't get overlooked. Stay informed about regulatory changes by regularly monitoring updates and changes to the FinCEN website. Keep your eye out for notes and reports about this in the media and from legal alerts and things like that from us. And make sure you're ready for any new changes in the reporting requirements. You're going to want to develop a system for promptly reporting changes in beneficial ownership information, and it makes sense to look into technology and software solutions to streamline the reporting process and improve accuracy. This is true especially if you are likely to have lots of compliance obligations and changes to report. If you're in a company that is actively engaging in lots of financial transactions of the sort we're talking about, it makes sense to use these tools. Compliance management software can assist in maintaining beneficial ownership records and generating the required kinds of reports. It makes sense to consult a lawyer when engaging in business transactions like mergers, acquisitions, or changes in ownership structure. It makes good sense to have solid legal counsel to ensure that the CTA requirements are met during these transactions, as are all the other requirements. So these proposed compliance strategies are meant to help reporting entities navigate the complexities of CTA and ensure that they fulfill their obligations accurately and in a timely fashion. Implementing compliance measures effectively is essential so you avoid the consequences associated with non-compliance. More information about beneficial ownership information can be found at FinCEN's website, fincen.gov. They also have a really good FAQ page at fincen.gov/BOI-FAQs for frequently asked questions. And that's it. I hope this has been helpful for you. Good luck, and reach out to us if you need any assistance.